I guess I should mention I'm also a planning commissioner. And I'm really excited to have helped organize this with Council Members Davis and Hara, and they are here to join us as well. And so I want to turn it over to them to say a few words before we get into the nitty-gritty with our legal experts from Betsettic and LAFLA. Thank you so much for coming.
Thank you, Lisa. And this is Colleen Davis, one of your Santa Monica council members. I just really want to thank everyone from Glaser Weil, LAFLA, Betsettic, for working so hard to put this on. We know these are very difficult times in our community, and a lot of uncertainty is surrounding the relationships between landlords and tenants. And the information is changing on a minute-by-minute basis. So I'm so happy that everyone has worked so hard to put this together to give you the best information so we all understand what our rights are, and more importantly, that there will be an opportunity if you need a one-on-one consultation to have that. So I just really want to thank everyone who put this all together and say that we're here to support you. Thanks.
Muchas gracias, concejal Davis. Muy buenas noches tengan ustedes. Yo soy su concejal Ana María Jara y primeramente quiero empezar dándole gracias al grupo que nos ha ayudado a participar en este consulta para todos ustedes, para que ustedes conozcan sus derechos, a LAFLA, a Glaser Weil, a todos los abogados que están presentes acá. Muchísimas gracias por darnos la oportunidad para que podamos mantener a la comunidad informada acerca de sus derechos. Lo que les quisiera pedir a todos los que están participando ahora es de que tengan confianza, que hablen con la verdad con los abogados para que así ellos les puedan ayudar y sepan ustedes en realidad cómo poder proseguir de aquí en adelante. Nosotros estamos aquí para ayudarlos y son servicios que nuestra ciudad les está prestando a ustedes, así es de que utilícenlos para que así ustedes también se puedan ayudar. Muchísimas gracias.
Okay, great. So I think let's turn it over to start our presentation.
And Josh, if you can go ahead and share your screen, I'll just introduce myself. My name is Hannah, and I'm an attorney with Betsettic. And we will also have Romy from LAFLA speak today.
Hello. Thank you, everybody, for joining us tonight.
Okay, 1 second. I just need to.
And for participating in this Zoom. I know we all spend a lot of time in front of our computers these days, and everything's a new challenge with this Zoom world. So thank you for bearing with us tonight. Great. So thank you for joining us tonight at this Tenants' Rights Workshop on COVID-19 protections. Thank you everybody from coming out for this event from the community, from the city of Santa Monica, and from our organizations, Betsettic and LAFLA. So this is a brief agenda of what we're going to cover tonight. First, we're going to do some introductions of those organizations that are here tonight. Then we're going to do a brief overview of the unlawful detainer or eviction process. Then we're going to do a brief overview of the Santa Monica's tenants' rights. And then finally, we're going to talk about some COVID-19 eviction protections.
Hi, so this is Hannah again from Betsettic. We provide legal services to low-income residents throughout LA County, and we serve clients regardless of immigration status or race, religion, ethnicity, or gender identity. Our Preventing and Ending Homelessness project provides eviction defense services for residents of the city of LA, Beverly Hills, Culver City, and West Hollywood.
I have somehow lost the screen here. I'm sorry about that. LAFLA has been around for 91 years. We just celebrated our 90th anniversary last year. We provide free legal services to tenants in Los Angeles County on a variety of civil legal issues. We have 5 neighborhood offices, including our office in Santa Monica, which represents and works with residents of the city of Santa Monica. We have 3 domestic violence clinics, and we have 4 self-help legal access centers. In 2019, LAFLA helped more than 100,000 people in cases ranging from eviction defense to family law issues to assistance at our self-help centers.
Hello, I'm Etta Sa, Chief Deputy City Attorney in the Public Rights Division of the Santa Monica City Attorney's Office. The City of Santa Monica offers a wide range of services and protections. The City Attorney's Office Public Rights Division works to protect the public rights of tenants and strives to advance the interests of the people of Santa Monica and the state of California. The division helps tenants and landlords understand their rights and responsibilities and enforces the law through court actions. The division answers questions and takes complaints from tenants and community members about the city's eviction moratorium, tenant harassment ordinance, relocation laws, fair housing laws, other housing related laws, and consumer protection issues.
One of the most important things that we want you to take away from this meeting tonight is that we are all here to help you. There are several laws that protect tenants in Santa Monica. Tenants who have lawyers are more than 70% more likely to avoid eviction than those who don't. So please contact Betsettic or LAFLA if you have any questions. And please do not wait until you're already in court. We're here to help you. This chart is a brief overview of what the unlawful detainer or eviction process looks like. So every unlawful detainer starts with a notice. That notice could be a 3-day notice, a 15-day notice, a 30-day notice, or something similar. The notice would be given by the landlord to a tenant asking the tenant to do something. If you as the tenant don't comply with the notice, the landlord can file a complaint for unlawful detainer or an eviction lawsuit in court. If the landlord files an eviction complaint, the court will issue a summons. Then the landlord can serve the summons and complaint together on the tenant. Once the landlord serves the summons and complaint together on the tenant has about 5 days to file an answer in the court. If a tenant files an answer in the court, then the tenant has preserved the right to defend themselves in the eviction case. If you file an answer, you could try to settle the case with your landlord and reach an agreement, or you can go to a trial. If you win the trial, then you'll stay in your apartment. If you lose, then the landlord will get possession of the apartment and could proceed to have the sheriff lock you out. If you do not file an answer within the time frame to do so, then the landlord can ask for what's called a default judgment. This means that you have lost the opportunity to defend yourself in the eviction case, and the landlord will automatically win. If the landlord gets a default judgment against you, then again, they can proceed to have the sheriff lock you out. This is why it's very important that you contact and seek legal assistance as soon as possible if you receive any sort of notice or court documents. This is what a summons looks like. So if you receive a document that looks like this, this means that an unlawful detainer or eviction case has been filed against you. If you receive this, please seek legal assistance as soon as possible so that we can help you in preparing an answer and advising you on your rights. This is a very brief overview of some important Santa Monica laws that protect tenants. The first law is rent control. Rent control in Santa Monica applies to most units that were built before April 10th, 1979, and rent control limits how much the landlord can raise the rent for those units. In addition to rent control, there's also laws that require landlords to have just cause or a good reason to evict you from your apartment. Just cause applies to most units in Santa Monica, even if they are not otherwise covered by rent control. In addition to these laws, Santa Monica has a tenant harassment ordinance, which prohibits landlords from harassing their tenants in bad faith. And finally, Santa Monica, California, and at the federal level, there are several anti-discrimination laws that prohibit landlords from discriminating against tenants on the basis of things like race, disability, family status, and other classifications. Now we're going to start talking about some of the specific COVID-19 tenant protections. So first, we're going to talk about the state law, which for the most part governs evictions for non-payment of rent. Then we're going to move to talk about the Santa Monica emergency orders, and those primarily cover evictions for other reasons other than non-payment of rent. And then finally, we're going to talk a little bit about an order from the CDC at the federal level, which is a little bit of a last resort protection for tenants here in California and Santa Monica. So if you can't pay the rent because of COVID, one of the most important things to know is you are not alone. Many tenants are not able to pay their rent right now because of COVID. Now, you may have already told your landlord that you can't pay the rent because of COVID earlier this year. If you did that, that's great. You may have availed yourself of some important tenant protections. However, even if you've already told your landlord that you can't pay the rent because of COVID, there is a new state law that will require you to take some additional steps to make sure that you won't be evicted for not paying the rent. So specifically, for rent that's owed from March 2020 through August 2020, if you can't pay the rent during that period of time because of COVID, then you can give your landlord a declaration of COVID-related financial distress. If you give your landlord this declaration, then your landlord can never evict you for not paying rent that came due during this period of time. So this chart shows a little bit of what your options are if you get a notice to pay rent that's looking for rent from March 2020 through August 2020. So first of all, the notice that you get would be a 15-day notice to pay rent or quit. If you get a 15-day notice that's asking for rent from March 2020 through August 2020, your first option, of course, is to just pay whatever is asked for in the notice. If you do that, then you get to keep the apartment, no problem. If, however, you're not able to pay the rent that's due from this period of time because of COVID, then you can give your landlord a declaration of COVID-related financial distress and still stay. Now, I should mention, for both of these options, either paying or giving the declaration of COVID-related financial distress, you must do this within 15 days of getting the notice to pay rent or quit from your landlord. If you don't do either of those two options, you could, of course, move out, but then you would lose the apartment. And if you do nothing at all, you don't move out, you don't pay, you don't give a declaration, then your landlord can take you to eviction court and ask to have you evicted for not paying the rent. Now, if you owe rent from September 2020 through January 2021, there's a very similar process, but there's an extra step. So if you receive a notice to pay rent or quit that's looking for rent from September 2020 through January 2021, and you can't pay that because of COVID, again, you can give the landlord a declaration of COVID-related financial distress, and then you must pay 25% of each month's rent between September 2020 and January 2021. You must pay 25% of each of those months' rent by the end of January 2021. If you do those two steps, then you can never be evicted for the remaining 75% of the rent that you haven't paid. This chart again sort of summarizes what your options are. So again, if you receive a 15-day notice to pay rent or quit that's looking for rent from September 2020 to January 2021, your first option is to pay everything within 15 days of getting the notice, and then you get to keep the apartment. Your second option, if you cannot pay what's asked for, is to give a declaration of COVID-related financial distress, then pay 25% of the rent for each month that is asked for in the 15-day notice. And as long as you pay that 25% by the end of January 2021, you get to stay in the apartment. The landlord cannot evict you for not paying the remaining 75%. Of course, you could move out, in which case you would lose the apartment. And if you do nothing at all, then the landlord can take you to eviction court and ask to have you evicted for not having paid the rent.
So this is an example of a 15-day notice to pay rent or quit that you might receive from your landlord. And the English is on the left, Spanish is on the right. Now, as we explained before, a written notice is the first step in the eviction process. And so this 15-day notice is just one type of eviction notice. Now, the 15-day time period refers to court days, so it doesn't include weekends or judicial holidays. Now, this is what your notice would look like if it was based on unpaid rent from the period of March to August 2020. It will say notice of non-payment of rent between March 1st, 2020 and August 31st, 2020, right here up at the top. And then there are spaces for the landlord to put exactly how much rent is owed for each month. So the notice should tell you also that if you sign and deliver a declaration of COVID-19 related financial distress to your landlord, that you can't be evicted for not paying the rent. Then this next slide is what a 15-day notice to pay rent or quit would look like if it was based on September 1st, 2020 to January 31st, 2020. And you can see those dates up here at the top. It lists this time period. Now, the notice should tell you that if you sign and deliver a declaration of COVID-19 related financial distress to your landlord, and you pay 25% of each of the months due for September through January 2021, by the end of January, that you can't be evicted for not paying the remaining amount. It's possible that your landlord will ask you to complete a new declaration for each month between September and January. So, you know, if you gave your landlord one for September and October, and then the landlord would be able to give you a new 15-day notice and require a new declaration for, you know, the next 3 months if the landlord wanted. Okay, and now this is the declaration of COVID-19 related financial distress that we've been talking so much about. So the declaration asks you to declare that you're unable to pay your rent or any other sort of financial obligations under the lease in full because of one or more reasons related to COVID. And you also have to declare that any government assistance that you've received doesn't fully make up income or increased expenses. Now, if your landlord negotiated your lease with you in Spanish, Chinese, Vietnamese, or Korean, they actually have to provide you a declaration in your own language. So let's talk specifically about what this declaration of COVID-related financial distress says. So it asks you to declare that you can't pay rent for one or more of the following reasons related to COVID. So that could be loss of income, increase in expenses related to performing essential work, costs related to health impacts of COVID-19, childcare or family responsibilities, or other financial impacts of COVID-19. And it's important to know that only one of these reasons has to apply, not all of them. And you don't even need to tell the landlord which of these reasons applies to you. So for instance, if the restaurant you used to work at closed because of COVID and now you don't have a job, that counts as loss of income related to COVID-19. Or if you had to stop working because your kids were sent home from school after the pandemic started, that's also a loss of income due to COVID-19. And then if you're able to keep working, but now you have to pay more for childcare expenses because the schools are closed, now that counts as increased expenses due to COVID-19. And you should remember that you'll have to sign this under oath, under penalty of perjury. So it's important that the declaration is accurate, that it's true that you can't pay your rent in full because of, one or more of these reasons. So if you receive a notice to pay rent or quit, you'll need to return a declaration of COVID-related financial distress to your landlord within 15 days in order to get the protections of this law. We definitely recommend that you contact one of our offices for legal assistance right away, because it's really best to get help with this process, especially if you have questions about whether your loss of income is qualifying or anything like that. Now, if you haven't gotten a notice to pay rent or quit, it still might be beneficial for you to provide the landlord with a declaration. And again, contact one of our offices for assistance with this process. Okay, now the 15-day deadline is very important, and we definitely recommend that you do everything you can to meet that deadline. But if it turns out that you missed the deadline for a good reason, the court might give you another chance to provide the declaration. So you should contact one of our offices to get legal advice right away if you get a 15-day notice. And then you should definitely contact us, even if you got it and you did nothing, or, if you didn't realize you got it and then you ended up getting court papers for an eviction case. We definitely want people to contact us so that they can, do everything they can to exercise their legal rights. And again, just want to reiterate that if you get any sort of court papers, you should contact legal assistance immediately so that you can get help with that. Now, most tenants don't have to provide any sort of documentation that they've been impacted by COVID if they want to be protected by this law. All they have to do is provide the declaration. But there's an exception. So landlords can ask you for proof if the landlord already has some evidence that you're what's called high income beforehand. And this high income number, it's just based on, you know, the median income in the county. So for instance, if on your rental application, if you told the landlord, you know, a couple of years ago that you were making, let's say, $150,000 a year, the landlord could ask you for proof of your COVID-related financial impact. And that could mean a letter from your employer about a layoff. Now, if a landlord asks for this information illegally, you know, when they didn't have any sort of basis to think you were already high income, there could be consequences for the landlord. So the landlord might have to pay your attorney's fees, for example. So again, you should definitely get legal advice if your landlord gives you a declaration to sign. So we mentioned earlier that if you follow these procedures, meaning that you have, you know, signs the declarations, given them to your landlord, and that you've paid that 25% of your rent from September to January, that you can't ever be evicted for the remaining rent. But it's important to remember that you still owe the rent. That hasn't gone away. So the landlord can seek that remaining rent from you in small claims court. And this could happen as early as March 1st, 2021, although local protections could push this date later. Now, if your landlord files a small claims case against you for the rent, you are allowed to countersue the landlord. Or you can also argue that, you know, for instance, if you owe less rent than the landlord is claiming because the landlord failed to make necessary repairs. So some of you may have heard about the Santa Monica emergency orders over the last few months, and you may have already provided notice to your landlord that you couldn't pay your rent due to COVID. And as Romy said earlier, that's great. And we're really glad you were able to find out about your rights under Santa Monica law. And you may be entitled to even more protections under the city law, but you should still follow the state law procedure that we just talked about. That means you should still give the landlord the declaration of COVID-related financial distress. And you should still pay 25% of your rent by January 31st, 2021 to avoid being evicted. Now, it's possible that you could have until September 30th, 2021 to pay the rest of your rent under the Santa Monica law. And that's, you know, if you were able to take advantage of the Santa Monica protections and you did what you needed to under that law.
So I'm going to explain the Santa Monica Eviction Moratorium protections that are in effect starting October 1st of this year to the end of this year, December 31st. That is a part of the eviction moratorium, the city's eviction moratorium that has been extended through the end of the year. Santa Monica's emergency order applies through December 31st, 2020. It prohibits certain evictions that don't relate to rent payments. There are no evictions for unauthorized occupants or pets. For example, if an adult child and their dog move in with you but are not added to the lease, you cannot be evicted for that. Most nuisance evictions are prohibited. A nuisance is an annoyance, hazard, or harmful activity that reaches a certain level, such as loud music or having lots of trash in and outside one's apartment. In order to try to evict for nuisance in Santa Monica, a landlord must always give written notice with an opportunity for the tenant to stop. With the moratorium, a landlord cannot evict for nuisance unless the nuisance substantially endangers health and safety. There are no evictions for failure to provide access to apartment. California law has always restricted when landlords can enter tenants' units. With the moratorium, tenants can deny entry unless the landlord is trying to make repairs that are necessary for health and safety. And finally, there are no evictions where the tenant didn't do anything, but a landlord would normally have the right to evict. For example, owner move-in evictions, evictions to convert apartments into for sale units or condominiums, which are often called Ellis evictions, or evictions that don't give any reason at all.
We're just going to take a second to make sure we're all on the same slide, and then we'll go ahead. Okay, so it's possible that your landlord might not follow all of the laws that we just discussed. Now, if they don't, remember that you still have rights. So if your landlord files an eviction case, even after you provided the declarations and you provided partial payment of rent, you might have a defense to the eviction lawsuit. And if your landlord isn't following the Santa Monica protections, you may also have a defense to the eviction lawsuit. Now, your landlord could also be subject to other penalties and fines. You should definitely get legal help and advice. You can contact Betsettic at 323-939-0506 or LAFLA at 1-800-399-4529. You can also contact Santa Monicans for renters' rights at 310-394-0848 or the City of Santa Monica at 310-458-8400 or by contacting info@smgov.net. One second, actually, I'm learning that we are unable to hear the Spanish. Josh, has that been fixed, or? Yeah, do you want to just say something briefly so Josh can make sure that he can hear you? Josh, I'll assume that if you change slides, I'll assume that it's okay. Okay. So now we're going to talk briefly about another law. So we talked about California law and Santa Monica law. And then in addition, there's a nationwide law called the CDC Order that might help you. Now, this is from the Centers for Disease Control and Prevention, and this order temporarily stops evictions until January 1st, 2020, only for certain evictions. Now, it requires a different declaration than the one that we just talked about. So you'll have to make statements about your inability to pay rent, your efforts to obtain assistance for rent or housing, and the risk that you'll be homeless if you're evicted. Now, it doesn't require any sort of connection to COVID, so you can use this declaration if you owe rent from before COVID, or if you can't pay rent for a reason other than COVID, or if you signed a move-out agreement but you never moved out. Because the other laws we talked about today are generally more protective for residents in Santa Monica and in California. The CDC order is usually just a last resort if nothing else applies. And you should definitely seek legal advice if you have questions about this. And the CDC, again, is the Centers for Disease Control and Prevention. So that's a federal agency. Now we're going to stop for a second. Well, I guess we can, Josh, if you want to give me a thumbs up if you're okay with going ahead, even though you can't hear the Spanish. Okay. Okay, so here are a few takeaways from the different laws that we discussed today. There is, the California law we discussed, which says that if you comply with, all of the requirements, that means that you give the conditions you're supposed to give and you give the partial payments for September through January. That means you can never be evicted for COVID-related rental debt from March 2020 through January 2021. Now, the takeaway from the Santa Monica emergency orders is that those laws prohibit evictions, certain evictions that are for reasons other than non-payment, right? So, owner move-in, unauthorized occupants, things like that. And then the CDC order that I just discussed, that can delay, but not prevent, delay eviction if you owe rent from before COVID, or if the reason you can't pay is unrelated to COVID, or if you already have a judgment of eviction. Okay, and there's one more law that we wanted to tell you about today. So in California, landlords cannot raise the rent by more than 10% right now due to the current state of emergency. This is going to apply at least through March 25th, 2021. And it doesn't matter if your unit is rent controlled or not. This applies to all units in California. Thank you so much for listening to our presentation today. In a moment, we're going to provide information for tenants who have questions about their housing and want to speak with a lawyer tonight. Now, if you don't need to speak with someone at the moment, keep in mind that you can always contact us later to discuss any issues that come up with your housing, like if you get a 15-day notice to pay rent or quit. You can reach Betsettic at 323-939-0506 or at housinghelp@betsettic.org. And you can reach LAFLA at 1-800-399-4529 or at www.lafla.org/get-help.
This is Denise, and I just want to give some information about what happens now. If you are a tenant and you want private consultation, you can click on the link that is going to be entered in the chat window. This will take you to a new Zoom meeting. We will meet you there shortly and give further instructions. Si usted es un inquilino y desea una consulta privada, haga clic en el enlace que se está ingresando en la ventana de chat. Esto le llevará a una nueva reunión de Zoom. Nos reuniremos allí en breve y daremos más instrucciones. If you do not need to speak to an attorney tonight, please feel free to contact us in the future at LAFLA 1-800-399-4529 or www.lafla.org/get-help/ or at Betsettic at 323-939-0506 or housinghelp@betsettic.org. Si no necesita hablar con un abogado esta noche, no dude en ponerse en contacto con nosotros en el futuro. Y los estamos poniendo en el chat los números de teléfono y el contacto en el internet.
So I'm going to go ahead and join the new Zoom meeting, but I would like if maybe if Josh can stay behind, so people are able to, like, if basically if someone tries to go into the new Zoom meeting and they get lost, it doesn't work, just go back into the old one and hopefully Josh can troubleshoot. Okay. Okay. Thank you, everyone.